the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. This is For the People, which is called For the People because it's for the people. This is our third show, and I want to kind of briefly give you a history of what we've done in shows 1 and 2, in case you haven't heard them. They're very good. You should go back and listen to them. What we're going to talk about is the legal system from the inside. I wrote a book called From the Trench to the Bench. In fact, somebody asked me the other day, said, what's the trench? Is this a war movie or something? I said, no, the trench is where the lawyers fight it out. And everybody's got a motive. The client's got motive. They got a motive. There's all kinds of money involved, and that's the trench. But I was appointed to the Superior Court in 2008 as a judge pro tem. I'm still sitting in that. In fact, I was just mentioning to Gary today, I had a case on Tuesday, which I thought was very entertaining. It was a bounty hunter.
Really?
It's like right out of the TV show. This guy was eating in McDonald's, big expenses. McDonald's. He did a Burger King one night, but they did get the guy, and they dragged him back in. So I asked the bounty hunter. I said, "Well, what was the underlying charge?" It was a second DUI, drunk driving case, or driving under the influence case, and obviously he was facing automatic jail time. So he just took off and ran off to Tennessee. But he got caught. And, you know, I watched the show Bounty Hunter and everything. It was kind of interesting. Yeah. I get interesting stuff, I must tell you.
Yeah, you do.
I got to tell you, I'm going to tell a story in a minute. But the purpose of the show is to, number one, inform the public what the legal system is really about from the inside and giving you the perspective from what the judge sees. And since 2008, I calculated I must have heard or handled at least 10,000 cases, mainly in small claims, restraining orders, landlord-tenant, and general civil litigation. So we really have to know a lot about a lot of different subjects. Like I learned all about bounty hunters. So we're going to inform you as to how the system operates. We're going to entertain you, hopefully, by telling you some great stories. They're all true stories, by the way, of cases either that I was involved with as a lawyer, and I practiced full-time for about 50 years. And so you'll hear that, but you'll hear what judges generally think. That should help you out.
Can I ask you a question?
Sure.
Do judges, like, you know, with the holidays and all that, are they more lenient, like, you know, during Thanksgiving week or Christmas and during that? Does it matter, or is there any? I'm just wondering, like, is it a good time to go to court during the holidays?
You know what? We used to call them Christmas juries. You want to try a case during Christmas if you're a plaintiff, because people are more receptive to giving. And if you're a plaintiff's lawyer, especially if you're on a contingency case, you definitely want to have that kind of jury. But it's interesting you mentioned it, because I was sitting in Beverly Hills a number of years ago doing landlord-tenant, basically evictions and things like that. And there was already an order from the prior judge kicking this lady out. And she had come in what they call ex parte to ask for basically a little more time. And so I listened to her. It was the day before Christmas. They wanted to throw her out.
What?
Day before Christmas.
Come
on. I said, so she came in and whatever, and the landlord, of course, objects to everything. So I said, you know what? I'm going to give you 2 weeks. Let's get the holidays done. I don't want you living in a car with your kids. It was Christmas.
Yeah, come on.
So I was pretty cool. So as I'm getting off the bench, the clerk looks up at me and she says, you know, my regular judge, because we sit in for judges who are out. This guy was out playing basketball. That's why he wasn't there. He was going to some basketball tournament or someplace. So I'm sitting for him, and I said, well, you know what? Everybody's different. It's Christmas. I'm not putting this lady out in the street. He's not going to do it. The landlord's not going to sell the building in a week or 2 weeks. What's the real loss? He's going to get the building back and whatever it may be. She says to me, you know, you're a softie. I said, well, I guess I'm a softie. I tend to be a little bit more emotional, I think, but I never let it interfere with the decision-making process. If it's a discretionary call, and a lot of things happen in the court system are discretionary calls, you know. If it's a discretionary call, I try very hard to bend over backwards to help the people out as much as they can. So the second element of our show is to entertain you. So I'm going to tell you stories like I told you the story about the $4,000 check last week. If you didn't hear the show last week, you missed a great story. And the third aspect is to give you guidance. I don't give you any legal advice because every case is different. I don't know all the facts. There's no attorney-client relationship. But I give you guidelines. And it seems to me that if you know in advance what you're likely to see, you're going to be a whole lot less stressed and a whole lot less anxious, and knowing what's looking ahead for you, and if you go ahead and do something about it.
Yeah, what to expect.
Yeah. And I can't speak for all my colleagues, and there's some great judges and there's some pretty awful ones. We talked last week about some people get appointed, An old friend of mine who had the worst reputation on the bench. I heard this from friends of mine. He was a good friend of mine, And I would go into court, and he'd be yelling, screaming at people, and he would stop. He would see me come in the door, and he'd put his hand up and say, come on, come up here. So I'd go up there, and then he would talk nice and soft. We were friends for many, many years. So he had a phrase that, some of these judges think they've been anointed instead of appointed. And that really is true. There are some judges who do terrible things. In fact, I was reminded of a story where a guy was arguing in the Court of Appeals. We have 3 judges called justices. And one guy said to the guy arguing, he said, if you're trying to put me to sleep, you're doing a great job. How do you think that lawyer felt standing there at that podium in front of a room full of people?
Like an idiot?
Well, I got a better story. This guy was such a bad guy. I'm not going to mention his name, but anybody who's ever practiced around here will probably recognize it instantaneously.
Judge Ito?
No, I don't know Ito.
I know. I'm kidding. I keep on throwing that one out.
Every week you ask guys. So I'm sitting in the courtroom. This has got to be 25 years ago, maybe more. It was in Santa Monica. And the way they did it those days is every case was called in the morning. It would be 30 or 40 cases on the calendar. This was called law in motion, meaning lawyers would make motions, the judges would rule on them, and that would dictate what was going on with the rest of the case. So I'm sitting in the back. I must have been number 30-something, whatever. You got to sit and wait. This young lawyer stands up, and while he's starting to argue, the judge says to him, do you have a state bar card? And why would you want to see a state bar card? So he says, he mumbled a little bit, and he says, why? He says, because I think you're so incompetent, I can't imagine the state would give you a license. And there's a room full of lawyers. He must have been like number 8 on the calendar. And the kid, he was a kid,
Yeah.
Of course, to me, every day now, everybody's a kid.
I'm a kid.
Everybody, you are a kid. So the bottom line was this kid shrunk 4 inches, and he wasn't even getting older. So the reality is there's some good, there's some bad, and there's some ugly. I mean, it truly is a crapshoot. And that's why I always tell people, try to settle your case. In fact, when I tell people that they're going to have to go to trial, I always say to them, who do you think your jury is going to be? And they say, well, I don't know. I said, that's exactly the point, isn't it? I'm going to tell you a good jury story. True story. My brother-in-law was in the tile business, and he would buy equipment from time to time. And he bought this equipment, and there was an option at the end of the deal that he could buy the equipment for $1. You keep it, you lease it for 3 years or whatever it is. So he made all his payments. He had excellent credit, made all the payments. Comes the end of the lease, he tenders the $1, and they say to him, no, we're not giving you this equipment for $1. But I have an agreement. No, we're not giving you the equipment for $1. You owe $3,500.
Wow.
So he said, well, I don't have it, and I don't owe it. And he said, you know what? We'll tell you what the result was after the break.
KCAA. Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Welcome back to For the People. I was saying just before the break, nothing in litigation is certain, except one thing. It's uncertain. So I want to tell the story about my brother-in-law. Good guy, legitimate businessman. They chased him for the $3,500 and they sue him. He wasn't doing really well at that moment because his credit had been adversely affected. And so I said, I'll represent you on this case. It wasn't only about the $3,500, because it's hard to litigate a case over $3,500. But I said, they've ruined your credit unjustifiably. So what I'm going to do is I'm going to sue them back. And I'm going to sue the collection agency that wrote you the most nasty letter threatening to put you and your children out onto the street. It was a horrible letter. At the end of the trial, I blew that document up, into a big poster size and had it right there on the easel for the jury to look at. It was a horrible, horrible letter, whatever it is. And so we put on the evidence, and it was a jury trial in Santa Ana. And at the end of the trial, we do our closing arguments. And I make the pitch that this was horrible, the collection agency, miserable, treated people with no dignity, yada, yada, yada. And the lawyer for the collection agency was obviously very inexperienced. And it's kind of interesting. A couple of years later, he appeared before me.
Oh, really?
Yeah. I recognized him,
Did you say anything to him?
I did. I said, I'll recuse myself if you want me to, because, of our past experience. I didn't say anything on what it was. He says, you know what? That letter really was helped this guy out. Why is that? Because now that they're all living in one room, they can get along better together.
Oh, God.
I could feel the room drop in the temperature. It was like horrible. And the other lawyer for the lending company, this was his first trial. He was a nice fellow, but he didn't know what side of the room to stand on. I mean, this was his first time in the courtroom. I had already tried probably 80 some odd jury trials by then. And so the jury goes out, whatever it is.
By the way, how much did you countersue him for?
Oh, I'm glad you asked that. I was going to just say so. Okay. I sued him for $935,000.
Wow.
I took the position that he couldn't buy equipment, and the numbers of his business after they had written this letter and ruined his credit affected his profits and his business and his gross and everything else. And I put on a whole dog and pony show. And they didn't really have anybody except the guy from the collection agency. He was not a terrific guy. He didn't come across really well. So I asked for $935,000 saying, okay, you might as well ask for the moon, right? Jury was out like about 4 hours, not too long. They come back in. How much do you think they gave me?
God, I wouldn't even know. I wouldn't even guess.
What do you think? You heard what the case was basically
Well, I mean,
about.
he said it was $3,500. I'd say they gave you $25,000.
$935,000.
Gee, wow.
They gave me every dime that I asked for. I was shocked. I mean, sometimes you win these and you say, well, okay, great. Sometimes you lose them and you say the same thing. I've lost some, and I said to them, how did that happen? Things do happen. And we're going to talk about that during the course of these shows, because I'm going to give you some real examples for the purpose of showing you this could happen to you.
So let me ask you then. So what happened? You got $935,000. Did you? But they never paid that, did they?
We settled.
Of course they did.
We settled. They hired some appellate lawyers. The guy was a good guy. He was a good lawyer. He called me. He says, this is not going to stick in the Court of Appeals.
Yeah, of course.
$600,000 of it was punitive damages, punishment damages. Let me explain what a punitive damage is.
Yeah, that's good.
When you sue someone for a tort, meaning a civil wrong, and you allege it was done willfully, maliciously, in conscious disregard of somebody else's rights, there's a damage called punitive damages. That's basically given to punish you for what you did before, but in order to make an example out of you so you don't do it again. They don't stick very much. There's a United States Supreme Court case called Campbell versus State Farm that limits it to 9 times the amount of your compensatory damages, up to 9 times. You could figure 4 or 5 times is going to be the mid-ground for keeping punitive damages if you get to keep them. And the majority of this award was punitive damages. So this guy says to me, it's not going to stick. I said, yeah, you're probably right. Probably not going to stick. So let's see if we can settle it. It was an insurance company. Finally, an insurance company came in to defend him. No insurance company in the beginning. And so I don't think I signed a confidentiality agreement so I could mention it. I settled for about $600,000.
Wow.
6 something.
Wow, that's crazy.
And my brother-in-law bought a house.
That is awesome. So
I bought a car.
You bought a car.
I bought myself a Porsche. Because and my wife has been saying to me for years, you're not a kid. You shouldn't be driving a Porsche.
Sure you can. Why not?
I said, why not?
Exactly.
I'm going to get me a Porsche.
You got a great jacuzzi in the backyard of your place, too.
Whatever. But the point is that there are a lot of variables.
Well, let me just say, so they originally sued him for $3,500.
$3,500.
And you got him $600,000.
$935,000 on the verdict.
Right.
And so I talked to one of the jury foremen, and she was a really nice lady, very spiritual, and she was a member of the Baha'i faith, and they're very, very nice people. As a general rule, they're spiritual, nice people. So I said, what happened? She says, those miserable people, they did this to this poor man. His wife had testified, and all that. And they had 4 kids. They're living on the street. We weren't going to let them get away with it. And so sometimes emotions, because you asked me the question about emotions.
Right, exactly.
Jurors have a lot of emotions. Sometimes they don't like the plaintiff, and they'll find a reason and a way to make sure the plaintiff doesn't get anything. In fact, one of the things I want to talk about is jury selection. People think they just sit in the box. Well, no, it doesn't work that way. It's different between state court and federal court. State court, you get a chance to do what's called voir dire, means to see, to save. That's from the French. And you get to ask questions of all these jurors. And what I did for many years is while the judge is telling them where do you live and how many jury trials, they do this whole stuff, I'm memorizing the names of the people in the box. They call it in the box. And I'm memorizing the names. And now I get a chance to get up and talk. And I don't use notes for jury selection because it makes the jury feel you have more control. You're not reading off of a pad or anything like that. And I would stop. And I remember a juror's name was Garcia. I loved Garcia. Okay. Garcia was juror number 14 or something, an alternate or something. So you get challenges. Challenges are for cause, meaning that the juror said, I can't be fair, or you mean that's my cousin, or something like that comes up. Right. That's cause. The judge makes that decision. But we, as the trial lawyers, get what's called a peremptory challenge. A peremptory challenge is you don't like them. In other words, there are certain jurors for certain kinds of cases you don't want. For example, general rule, if you've got a case involving monetary damages in a business loss, profits, losses, or whatever it is, what you don't want is an accountant, because they're gonna make you toe the line. On the other hand, you like social workers in cases involving personal injuries because they tend to be more concerned about people and what they can do for the people and things of that nature.
Can I ask a question?
Yeah.
Is it the same jury selection for criminal and civil court? Is the same exact way? Okay.
Well,
cool.
you pick the jury the same way.
That's what I'm saying. You have the same challenges in the whole thing. It's the
well,
same.
the amount of challenges depends on how many parties there are. There are some variables as to what you do.
Okay.
And I liked Garcia a lot. He had all the right answers.
He likes you.
So what I did is I was the plaintiff. I passed for challenge the first round. Then it goes back and forth.
Right.
Then the defense lawyer was a guy with a big red face and a bow tie.
Santa Claus? No.
He was anything but Santa Claus. He's now gone now, and I don't expect we'll be seeing him on any reindeer. But he was a good lawyer. But so he exercised one challenge. Then it's my turn. I passed again, because you only get so many challenges. You get 6 challenges most of the time, and so I passed again. And he exercised another challenge. Now I'm 2 ahead of him, right? I waited. And I kicked off 3 in a row so I could get Garcia. And he was great. We got $1.5 million out of that jury.
Wow.
And the judge took all the money away. People always say, how that? After the trial was over, same judge who said to the kid, you know, do you have your state bar card? Same judge. He says to me, I'm not leaving your client getting any money here. He's a liar and a thief. He's not getting any money. We'll pay the mortgage on his house. His house had burned down. And it was an arson fire and all of that. But they couldn't prove it. And we got $1.5 million.
But they thought he did it?
Oh, they claimed he did it.
Okay.
He had gone bankrupt 3 days before. And he lied to him about some of the property. And
the jury still found for him.
So Garcia was right there. He was terrific. In fact, one time I had a case where the foreman, the defense lawyer was he got up after he questioned and objected. Juries do not want to be there. The longer you keep them there, the less they like you. Well, this guy, the kid, you know, he would stand up and object to every question. 95% of them would be overruled. He would stand up, he'd sit down, stand up, sit down. And I was watching the jury, and they're looking at me like, what is this you know, on and on and on and on and on. So we go to the end of the case, and that one we got $1 million too, matter of fact. My client was awful, but we won. I mean, I go figure that one out. And I said to the jury afterwards, they were so offended by the way this lawyer was handling the case that they paid him back. And so that verdict stuck, and the jury foreman became a client of mine.
Wow. What happened to the other one? What happened with the judge that rescinded the...
We went up on appeal.
Yeah.
And settled it.
Okay. Can you name the guy? Come on, you don't like him that much.
No, I can't. I don't know where he is. I don't even know where he is. But he was like an ambassador to something, and he was it's a great story. It's a long story.
It doesn't seem like he liked it too much, Judge.
Actually, he was a pretty decent guy. He had a great sense of humor.
Okay.
But he probably burned the place down.
Your client did.
Well, he wouldn't be the first one. You'd be surprised. I had a case one time where the guy wanted to sell his building, and he had insurance, and they were going to knock the building down and build a high-rise, something like that. So the value of the building didn't really mean anything. Whoever was going to buy it was going to knock it down. So all of a sudden there's a fire, and the guy dies in the fire. Not the client. The guy dies in the fire. What he had done is he went there, he poured all the gasoline out there, and he lit a match. He was standing in the doorway, and poof, he went up right with it.
Wow.
People do not understand that gasoline does not burn. Did you know that?
No, I didn't know that.
No, it's the fumes.
Okay.
So the place stunk. He lit the match, and poof, up he went, right?
Wow.
And then he tried to intimidate one of the witnesses. I mean, I tried that preliminary. I didn't do the whole trial.
Yeah.
I'll tell you more about that afterwards. This is For the People, and the book is called From the Trench to the Bench.
With Judge Herb Dodell. All right, we'll be back.
DC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, welcome back. The show is for the people, and this is Judge Herb Dodell, and we're telling stories like we tell every show, actually, but we're going to just divert from the great case that we were just talking about before the break. We're fortunate to have a guest today. We're going to have a guest every week, hopefully, and at some point people are going to call in. We talked about small claims court the last couple of weeks. And it's not any different than any other court in terms of the outcome. If you're the plaintiff, you want to get a judgment. A judgment means you can collect it. You can find the place where the money is. Follow the money, right? So our guest today is Howard Blum, who's a very nice man, but you don't want to get a phone call from him. All he does is collect the money. So Howard is going to tell you today, what do you do if you got a judgment? Let's say you're in small claims court and you just got a $10,000 judgment, and you're looking at the defendant and you're saying, okay, how do I get the money? People always ask me, how do you get the money? Well, Howard's going to tell you how to get the money. So good afternoon, Howard.
Good afternoon, Your Honor. How are you?
I'm good. So what methods are available for what's called a judgment creditor, somebody who's got a judgment in their favor? How do you go about collecting it?
Sure. The first thing to realize is that the judgment, although it's good for 10 years and can be renewed for another 10 years, it is not self-executing, which means that you have to do something. You have to take affirmative steps to collect the money. The court is there to provide you a forum for collection, to issue orders, issue other documents. But without your affirmative action, the judgment is simply a piece of paper. So there are a number of things that you can do. They take differing amounts of time. They have differing success rates. Some are more complicated than others. But they're all found in a law called the Enforcement of Judgments Law in the Code of Civil Procedure. The simplest methods to collect are bank levies, wage garnishments, debtor examination orders, and personal property levies. There are other procedures that you can employ. They get a little bit complicated. Those are the four easily utilized methods.
Let's just talk about a writ of execution. That's the first one.
Okay, well, a writ of execution is the document that the court clerk issues that you then need for a bank levy, a wage garnishment, a personal property levy, without the writ of execution. And that is actually the instruction from the court to the sheriff of any county in California to go do what you tell the sheriff to do. Without that writ of execution, you cannot levy on a bank, you can't conduct a wage garnishment, you can't pick up personal property such as a vehicle or a boat. So you need that writ of execution initially.
That doesn't have to
And
happen at San Quentin or anything, right?
no, no, it doesn't. You're not actually executing the judgment debtor. You're simply taking.
I didn't want to get overwhelmed with a $10,000 judgment. They hang you. Really.
You may feel like you would like to, but that's probably a story for another time
Yeah,
in
well,
the criminal law.
Us lawyers sometimes use terms that the public doesn't understand. The word levy. What is a levy?
The levy is the act by the sheriff of taking something from the debtor. So the process is, to simplify it, you have a judgment for $10,000. You get a writ of execution for that amount of money, which is issued by the court clerk, directed to the sheriff. Then, by form or letter, you tell the sheriff, go to this particular bank at this particular address and levy any accounts in the name of the judgment debtor. So the levy is the actual process by which the sheriff takes the property that you instruct the sheriff to take.
When you say he takes the property, does he physically takes the property, or does the bank give a check, or how does it work in terms of mechanics?
It depends on what you're instructing him to take. With a bank levy, the sheriff, or actually a private process server, a registered server, actually walks into the bank, hands the documentation to the bank operations officer. They then have to freeze any money in the name of the judgment debtor, any account in the name of the judgment debtor. 15 days later, they send the money to the sheriff. The sheriff sends it to the county auditor, and the county auditor sends it to the judgment creditor. If you're picking up, for example, a vehicle, if a vehicle has sufficient equity in it, you can actually instruct the sheriff to go to the debtor's residence or place of business and levy on a particularly described vehicle. They will actually hook it up, tow it to a certified tow yard. Then there's a process whereby it's put up for auction, and whatever money is realized at the auction goes to satisfy or partially satisfy the judgment.
What happens to the costs that you're incurring in order to have all this thing happen? Is it recoverable, or is it out of your pocket, or what?
Most costs that you incur post-judgment are recovered by filing a document with the court enumerating those costs. The cost of getting a writ of execution issued by the clerk, the cost of recording something with the county recorder, the fees that the sheriff charges to levy and sell a vehicle. Those are all recoverable costs. Process server fees are recoverable as well, in addition to interest at 10% from the date of the judgment.
Better than the bank. 10%.
I'm sorry?
10% is not a bad deal.
It isn't. Getting it is one thing, but it's a decent rate of return or a rate of interest.
What about a garnishment? What exactly is a garnishment?
A wage garnishment, suppose that you have a judgment against Mr. Smith, and you know that he works at ABC Corporation. You can serve a wage garnishment order on ABC Corporation, which requires them to withhold a certain amount of money from Mr. Smith's wages. And wages, the term wages is very generally described as money that a person gets for services. So whether it's called wages in the sense of a salary, hourly rate, commission, or otherwise, those monies can be garnished by a wage garnishment. The problem with a wage garnishment is 75% of the disposable income is exempt off the top by federal law. The remaining 25% can be exempted if the judgment debtor can make a showing of need. If he needs a vehicle to get to and from work, and it is not a high-end Mercedes or Rolls-Royce, the court is going to allow him to keep that vehicle and a certain portion of the 25%.
Well, I know that because I've heard many petitions for exemptions by people who come in and say that they can't afford it. They're taking 25% is making it difficult to survive. I'm generally pretty good. I just extend the terms of the payment schedule instead of grabbing it all at one time on a regular basis. And so we as bench officers will oftentimes think about that as to how we can get them paid.
Exactly.
All right, tell me about, you got a judgment against this person, but you don't know if they have any assets. You don't know what they got. How do you find out? I mean, I know the answer, but how do you find out?
Well, I hope I give the right answer.
I'll let you know.
Okay. You can retain a private investigator or a company that does asset searches. I have found that they are very perfunctory. A lot of these asset searches can really be done by an individual sitting at a computer and looking at certain open source public documents. But oftentimes, if your judgment is substantial enough, you may find that the judgment debtor appears to have no assets. Most people have something. They live somewhere, they drive a car, they buy food and entertainment and clothing, so they're getting money somewhere. These things don't necessarily show up on an asset search. So that leads me to one of the things you can do, which is conduct a debtor exam. That's an examination under oath in court. You serve the judgment debtor with an examination order. He or she is required to come to court and sit and answer questions under oath about their assets, liabilities, and financial condition. If they refuse to answer, they can be brought before a bench officer, such as you, who will, assuming the question is relevant, order them to answer, or they could be held in contempt of court. So that is one way to find out where their assets are.
Yeah, that's called an ORAP, right?
Yeah, a judgment debtor order for appearance and examination. So the first four letters, ORAP, order for appearance.
A lot of times they don't show up, so we have a procedure for that.
And that procedure is the issuance of a bench warrant.
That's what I do.
Right.
I issue a bench warrant for their arrest. I set bail. But what I also do is make sure that they get a letter first. I hold the warrant. When they say hold the warrant, it's not given to the cops to pick them up or her up. So I send them a letter, say, okay, you didn't appear. You show up on this next date. If they don't show up the second time, I issue a bench warrant. I don't hold it, set bail, and then they end up getting dragged in and they get arrested. And for some strange reason, they always get arrested on a Friday afternoon. I never could quite figure that one out, but they do.
And what I find oftentimes is judgment debtors know someone who can advise them informally, and typically the advice is, it is a court order. You have been ordered to appear. If you don't appear, this is the process, and it's much like you've just described. They typically do appear the second time.
Yes, they do. Yes, they do. And I'll tell stories about that during the next segment, maybe.
Right.
But in the meantime, I want to mention it's Howard Blum. Your office is in Woodland Hills on Oxnard Street. You're a great collection lawyer. And I encourage anybody who's trying to collect their money, give Howard a call. He'll know what to do. And that
Judge Dodell, thank you very much.
Well, it's been my pleasure. This is For the People. The book is From the Trench to the Bench, and we'll be back after this announcement.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, well, welcome back. That was certainly great information. If you want to get a hold of Howard, his phone number is 818-593-3910. It's always better to have a pro do it for you. Otherwise, you go round and round and you find things get in your way. The way to do it is get a professional. Now, I got to tell a story. Remember I was talking about the guy that went poof, the guy that died in the fire?
Yeah, the gas fume guy.
The guy didn't pay me. The lawyer didn't. The client didn't pay me. So I didn't do the trial. But he owed me the money. And so I said his ORAC, just that we were talking about. And he comes in, shows up, and he's wearing this fabulous gold Rolex. I mean, really nice. I don't know much from watches.
How much did he owe you, by the way? How much did they owe you?
I don't really remember.
Okay.
It was significant.
Yeah.
Because
Okay.
I had done a lot of work in that preliminary hearing. Was a lot of investigation was going on.
All right.
And the reason he burned it down is because he could sell the raw land and collect the insurance proceeds. So it was a double dip.
Right.
So that's what he did. He was not a terrific guy, by the way. There's more stories about him for another day.
Poof.
But but he had a nice wife. She was a very nice lady. I remember her.
Okay.
The bottom line is, I said, "Excuse me." I walked over to the judge. Right, you're in the courthouse, the courtroom actually, a little side room where you do the interview. And so I said, the guy's got a brand new looking gold Rolex with the diamonds and the whole thing. It sparkles real nice. So I said, I'd like it. I said, I don't wear a watch, but I like the way it looks. So he says, bring him in. So I bring him before the court, and the judge says, okay, take the watch off and give it to him. He says, what do you mean? He says, you heard me. Take the watch and give it to Mr. Dodell as part of your payment of what you owe him. Well, I don't know how much. We'll figure it out. So I said, I don't know how much I'll be able to get for this, but maybe I'll give it a try, And so
That's crazy that he literally he had to take the watch right off.
Yes, that's why when you have an ORAP done, here's a word of guidance. Don't go with any cash, because I have done it before.
Yeah.
What do you got in the wallet?
Really?
And if they get the cash, you go to the sheriff.
How about gold chains or anything? Right?
Anything.
Don't wear anything.
As long as it's not, they can't take your Bible.
Okay.
They cannot take your Bible. That's one of the exceptions. And so that's the benefit of an oral examination of a debtor. In terms of exemptions, I would say probably 80% of the time I knock the number down, because the creditor ultimately gets paid. It just takes a little longer. In the meantime, these people have an ability to continue living some meaningful life in the meantime, and they're paying 10% interest. So I've done that many, many times, but they have to fill out a financial declaration, which we look at. If that person is making big money, forget about the exemption. It ain't going to happen. So that's the way it works. People always want to know, what do judges do? How important are the judges? The judges really make the difference, all the difference in the world, because what gets into evidence in a trial depends on whether the judge overrules or sustains an objection. Overrules means not agreeing with you. Sustain means the judge is agreeing with you, and it doesn't get into evidence. And trials are very complicated matters. They cover long periods of what they call pleadings. I'm going to talk about all of this in one of the next shows. A little tutorial about how the civil litigation system works. What do you file? What do they file? What do you do when you get served? All those things. And then we get into discovery. Discovery is depositions and questions and interrogatories.
What about motions?
Motions are requests by one party for the court to grant or deny relief. And they're complicated. They require a lot of research. They're written in forms of briefs. They're called points and authorities. There are certain motions, which we're going to talk about in the next couple of weeks, called summary judgment motions. A summary judgment motion means that the case is over, or at least the part that you're seeking a summary adjudication, that's over. But if there's any issues of material fact, that motion has to be denied. Judges who want to get rid of their cases off their calendar, some judges have 500 cases on their load. They want to get rid of cases. Best way to get rid of it, grant the summary judgment motion, and they're gone. And that turns out to be most of the cases that end up on appeal. We're talking civil cases now, not criminal cases. Yeah. And next week, we're going to have a very exciting week because I'm going to talk about restraining orders.
Oh, yeah.
It's Jerry Springer without the chairs.
I bet.
And sometimes I have to kind of bite my lip because they're very, very humorous.
Well, I told you, you did my radio show a few weeks back, and I told you about how my ex-wife filed a restraining order against me, and for no reason, basically. And it can ruin your life, man, from what you told me.
What do you mean can?
Will.
It will.
Yeah.
People don't take it seriously until they have one on their record, and then they try to get a job. And then they apply, and they don't get the second interview, and they don't know why. I think I told the story last week, and I called a couple of big-time executives, and I didn't call them. I had my clerk call them and say, Judge Dodell, but they don't know who you are. But they hear judge, they think, oh, I better talk to this person. I don't know why they're calling me. So I talked to these people. I said, look, it's anonymity. I'm not going to tell anybody who you are, but I want to know because I issued these restraining orders. I want to know what effect it has on them, and I want to know from the horse's mouth, really. Yeah. And they said, we don't hire those people.
Yeah. By the way, they didn't issue a restraining order. I was like 100 miles away from where she accused me of being. So that was the whole thing.
Well, one of the things about restraining orders is, and there's a difference between a restraining order and a domestic violence restraining order. They're different. The domestic violence cases are heard in the family court, and they have to involve some relationship between the parties. The civil harassment or regular restraining orders are heard on a regular restraining order calendar. The burden of proof, which I explained last week, which is the obligation of one party who has the burden to satisfy it in order to prevail, is different. It's easier to get a domestic violence restraining order than it is to get a civil restraining order. And so...
why is that?
It's just in the law that way.
It's just in the law that way, huh?
Yeah, and the most important thing to remember about restraining orders is that it has to involve a continuing course of conduct. Very, very important. I have a whole chapter in the book about restraining orders, as a matter of fact. So here's a real case. A guy comes in, his face was all beaten up and everything else, and he was seeking a restraining order against the person that beat him up. And I said to him, when was the last time you saw them? It was a couple of months. He healed most of it by then. And so I denied it. He said, well, how could you deny it? The guy got beat up. He could sue him for assault and battery. I did mention this last week.
Yeah.
But it was not continuing course of conduct. There was no chance they were going to see each other again. And so, therefore, it didn't work in terms of a restraining order. But you see Gloria Allred on TV all the time?
She's been on my radio show many times.
Well,
yes.
Gloria was being harassed by somebody, was texting her over and over and over again, came in for a restraining order.
Yes.
And her partner, who I had known for many, many years, was in there. And what was happening is she was getting harassed. And so I listened to the testimony and I granted the restraining order. About 6 months later, I ran into that lawyer, Gloria's partner. I said, whatever happened? She said, the day you issued the restraining order and it got served, the last time she heard from anybody.
Really?
So it really does work. And it's easier on those kinds of cyberbullying or harassment by text, everything. It's easier to enforce those because people will come in with their cell phones. I mean, I've looked at a lot of cell phones. I want to tell you one quick story before we run out for today. A gal came in and said she was being harassed by this person. Cell phone, you know. So she gives the cell phone to the bailiff. The bailiff brings it up. I look at it, and there's a picture of the lady who was harassing her with a beer can in one hand and a gun in the other.
Wow.
With a note on the bottom, this is going to be you, or something like that. Well, you know I granted that one.
Of course.
And that person can no longer have a gun. In fact, it's interesting. I took a gun away from some guy who was a real threat. He says, but I'm a hunter. And how am I going to hunt? I said, go out, buy yourself a bow and arrow.
Exactly.
But you're not going to do it with a gun. I'll tell you that right now. And so that's one of the ramifications. And I'm a firm believer in the Second Amendment. I think people should have a gun. The question is, who are the people that are getting these? And so we'll talk about a suggestion that I have to in some way affect, minimize gun violence. It's an idea that I presented to the U.S. Senate about a year ago. Got great reviews, but they told me the chance of getting it past the NRA was zero.
Please.
So I think it's time to renew that.
Yeah, you should.
It's a great idea. So if you want to know what the idea is, you have to come back next week.
Yeah, absolutely. That would be cool.
And we'll tell some great stories about restraining orders. I'm still laughing at some of them.
Yeah, I want to tell you about mine if we can next week.
Ahead,
No,
yeah.
we can do it next week. I mean, like I said, I was going through a divorce, and she was seeing somebody else. And, I wasn't, we were going back and forth as you do with a divorce. And thank God, I happened to be going to Laguna Beach that weekend. And lo and behold, I got a phone call when I came back a couple days later stating that you have to go to court. It was Simi Valley, and you have to go to court because Jeannie's filing a restraining order against you. And I'm like, that was my wife. I'm like, what? Like, for what? Like, what reason? Supposedly, I was hanging out at her place, like spying on her and her boyfriend one night on a Friday night when I happened to be in Laguna Beach with a friend of mine hanging out. Luckily, I had a receipt for that night, a credit card receipt. I said I was like 100 miles away. So, I mean, I literally had to go to court and show the judge, like you, the receipt and where I was. And basically, he just said, hey, you know what? You guys aren't going to see each other anymore, and you guys aren't going to have more problems. And I go, yeah. She goes, yeah. And I go, okay, bye. And he said goodbye and let it go. But I was like, man, you're going to ruin my life, man. I mean, she was trying, I mean, it's pretty serious stuff. That's what I'm saying.
Oh, it's very serious. Not only the employment stuff, but an immigration lawyer told me not too long ago I was at some seminar, and we were talking about it because I had written an article on restraining orders. And she says, I have a client who wanted to go to Canada. His business was in Canada. He needed to go on a business trip to Canada. There was a restraining order against him. The Canadians wouldn't let him in.
Yeah.
So, people take it too lightly. Don't take it too lightly.
No, it was very
Get
serious.
a lawyer to defend yourself.
Or have a credit card receipt.
I'll tell you a story about a drunk driving case that I won because I did exactly that. I took the bar receipt, the restaurant receipt, and it showed that she and the two people that were with her, there were 3 glasses of wine. That was the whole bill. And there were 3 of them.
Yeah.
So obviously it was a good argument that she wasn't under the influence.
Exactly.
We'll talk about all of those when we get to criminal law, too.
Great show, Judge. Great show. I love you. Great show. I love it.
Thanks. Well, again, this is for the people, and the book is called From the Trench to the Bench, available at Amazon.
With Judge Herb Dodell.
And you can also contact me, and I'll try to get back to you. The email is askjudgeherb@gmail.com. No advice, but guidelines.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.